My lords and my ladies, on to my first point, whether this court should order His Excellency President Uhuru Muigai Kenyatta to refund the public monies used in the unconstitutional constitutional process. My lords, on this is a novel issue for the following reasons. No court in Kenya has made a determination on Article 226(5) of the Constitution. In the whole of Africa, South Africa in 2018 is the only democratic country that ordered His Excellency President Jacob Zuma to refund approximately 1 billion shillings used in construction of his house. That was the taxpayers' money. And my lords, the history of the erstwhile Constitution of Kenya, with its 6 provisions on public finance, never provided for a provision akin to Article 226(5). And for that reasons, my lord and my ladies, the High Court's findings and declarations at paragraphs 784 to 785 of their judgment, respectively, was sufficient for an order to make good the loss of public funds. No evidence was needed for that order to be made. No evidence. It is strict liability. No evidence was needed. And if any evidence was needed, it was the evidence in the special knowledge of the appellants. Section 112. He who pays the piper plays the tune. My lords and my ladies, in buttressing this point and these findings and declarations, we rely further on grounds 2, 4, 5, 8, and 9 of the 76th respondent's notice of grounds for affirming the judgment of the High Court, dated 4th June 2021. Additional declarations, we further rely on the 76 respondents' affidavit dated 27th June 2021 at paragraphs 7F, 7E, 8, 10, 18, 20, which affidavit has not been controverted by any appellants. My lords, I also invite you to look at the doctrine of public trust that we have talked about in our submissions. The doctrine is anchored in Article 73(1) and Article 1. Article 1 of the Constitution talks and says like this: mamlaka yote makuu ni ya wananchi wa Kenya na wanaweza kutekeleza tu kulingana na katiba hii. Mamlaka ya wananchi katika katiba hii yamepewa idara zifuatazo za serikali. My lords, there is a clear delimitation of who serikali is and who mwananchi is. My lords, I also invite you to look at the erroneous application of Article 35 of the Constitution, together with unreasonable reliance of the affidavit of the Auditor General at paragraphs 47 and 48 of our submissions, pages 47 to 48 of our submissions. And therefore, in conclusion, my lords and my ladies, with such demonstrable disingenuity, should the court fold its hands under the doctrines enunciated here of political rightness, mootness, political questions, I am afraid that the liberties of Kenyans and inalienable rights of the ordinary mwananchi would be suspended by a thread so slender than the hair strand that held the sword of the imperial King Dionysius over the head of Damocles. Thank you.
Council, do your best to stick to the time.
My Lord, I request for 5 more minutes. And by introduction, my name is
You will have to stick to the time, Council. We really are very, very pressed for time. I wish you could start.
I'll try, my Lord. My Lord, my name is Topuale Cinco for the purpose of the record. Topuale Cinco. And just before, my Lord, I proceed with my submission, I just want to make a rebuttal on what Senior Counsel Kamau Karori said regarding the interplay of Article 38 vis-a-vis Article 257. My Lord, the argument by the appellants is that the President is entitled to initiate a referendum on the guise that under Article 38, which provides for political rights, the President has a right to champion the cause. And I think Justice Kiage followed that. What really happens when the Parliament is robbed? My Lord, my submission is that there are enough safeguards that provides the President with avenue for lawmaking. And just to cite maybe one, under Article 261, my Lord, the President can actually have the Parliament dissolved if it's not performing its function. And under Article 1.4, the people can actually, my Lord, recall their representative where they are not providing or rather carrying out their mandate. And therefore, that is not a justification to abrogate the President the power to amend laws under Article 257. My Lord, the basis also for Article 257, which gives the ordinary mwananchi the right to amend the Constitution, comes from Article 1. The reading of Article 1, my Lord, and this is actually factored also through the history of the Constitutional Review Commission and the final report. Under Article 61, the Attorney General, my Lords, have considered to the fact that the question of amendment has never been contentious in all history making of in the constitutional history making of Kenya. Therefore, the people of Kenya had a very clear mind that they intend to undo that power that enabled the rock executive parliament to mutilate the Constitution. There was therefore no hard time, my Lord, to try to balance rigidity and flexibility to amend the Constitution. And that it's my submission that the powers that the legislature, the executive, my Lords, enjoy is derived from the Constitution. And when you consider like chapter 18, page 18, sorry, of the Njoya case, Justice Ringera talks about the constituent power being primordial, that over and above the constituent power, my Lord, being derived, it is also regional. That has to, it's two-pronged, my Lord, that the people are bound by the Constitution, but also the constituent power is original. And that actually takes us to a definition that in some instances that the people might not be bound by the Constitution. Any interpretation, my Lord, therefore, that says that the President is not entitled to initiate amendment of the Constitution through popular initiative, my Lord, I think will be the correct interpretation in that the people are the sovereign. They are the one who donated and constituted the legislature, the executive, and the executive can only act, my Lord, within the limit of the power that the people have donated. If the President, my Lord, therefore wants to amend the Constitution, and if it's indeed in the interest of the mwananchi, the President, my Lord, can actually resign and do that in his private capacity as a citizen. And I'll direct you, my Lord.
Mr. Siko, the point was well made. Please move on to the other one. You have 2 minutes precisely.
My Lord, I'll just direct you to a decision by Justice Nambuye between the Ethics and Anti-Corruption Commission versus County Government of Meru, where it was held that in the regime of the Bill of Rights.
Which decision?
Ethics and Anti-Corruption Commission, my Lord,
okay,
versus Think County Government of Meru 2018.
All right.
Justice Nambuya and retired Justice Philip Waki presided over that, and it introduced a dichotomy where you view the state, my lord, as a duty bearer and not the right holder. Therefore, the argument therefore that you can actually limit the right of the president to express his political rights for the interest of the local mwananchi, my lord, actually survives. My lord, as I conclude, I just want to point out what Dr. Diankolu left in the interest of time on the issue of political question doctrine. And our submission is that in as long as it is the interpretation of this court that the popular initiative is an individual right, then the political question doctrine should not arise. I will direct you, my lord, to abundance of authority the case of R. vs. Miller, concluded by the Supreme Court of the UK, and also the case of Becker vs. Carr. Justice Brennan, my lord, in that decision brings out a distinction that whenever power is clearly delineated between each arm of the government, such that when we're arguing about the executive, there's a clear line that their mandate is to do with things to do foreign relations, defense. The argument, therefore, that one has abrogated the power of the other, my lord, should not arise. And also, we provided an article by Professor Louis Henking, arguing that the political question doctrine is actually applicable in America and is an disingenuous legal mechanic to shirk off judicial responsibility. The Superior Court, my lord, has unlimited and original jurisdiction under Articles 165 to interpret, my lord, the Constitution, to promote in the interest of the local mwananchi, and that power is rightly delegated by the people under Article 1.
Thank you, Mr. Siko. Thank you very much.
Thank you, my lord.
Thank you. Senior Counsel Karua, are you here? Hamino, please. Can you take your 30 minutes right now?
With the court's permission, there is a young lady counsel, Caroline Kituko,
the one who was to appear online, virtually?
She's here now and she's requesting to be heard first. Her condition does give her to request the court to be heard first. Before? Yeah, she thinks too much sitting may affect her condition.
I see.
I would request
Dr. Amino, did you hear what Senior Counsel Karua said about Ms. Kituku, that her condition cannot allow her to sit down for long? She would like to make a short presentation. Before you do,
I didn't hear my own question. I will have to go ahead.
All right.
Thank you.
Unless you want to do it seated. Do you want to sit down?
No, my lord, I'm fine standing.
You're fine standing. Okay. Please introduce yourself for record purposes. And you need, I think 10 minutes would do.
No, my lord, I represent a main party, the respondent, Muhuri, Muslims for Human Rights, who was the main petitioner in petition E2 of 2021 in the High Court. So we'll be seeking to have 45 minutes.
We were calling you yesterday. You could not connect virtually.
My apologies for that.
We will give you a maximum of 30 minutes. We know you are that was the main petitioner. So go ahead right now.
Thank you, my lord. So the President of the Court and the Honorable Justices, my name is Caroline Kituku. I appear together with Mr. Muhuyu Moniki from Muhuri, the 26th respondent in the IBC appeal. We oppose the appeal And we have filed grounds of affirmation dated the 23rd of June 2021 that we're seeking the court to affirm the High Court judgment. We have also filed the submissions dated the 23rd of June 2021. My Lord, Muhuri's case seeks to challenge the actions of the IBC to process the BBI bill in violation of the Constitution. Muhuri submits that the actions of the IBC to receive the draft amendment bill, that is a BBI bill, together with the supporting signatures, and proceed to verify that the initiative was indeed supported by 1 million registered voters, and certify the bill and forward the same to the county assembly. The IBC acted in violation of the Constitution, and in particular sections 10, section 94, section 82(2), section 249, as well as article 257, 4 and 5. We say so because at the time the BBI amendment bill was received by the IBC, IBC could not properly, lawfully, and satisfactorily discharge its mandate under Article 257(4) of the Constitution because it lacked the sufficient legal and regulatory framework to process the draft amendment bill. Therefore, it could not proceed to verify that the bill was indeed supported by 1 million registered voters and certify it as such and forward to the county assemblies. To that extent, therefore, I shall address the court on 3 aspects. The first question is whether or not IBC required a legal framework to guide it undertake its mandate under Article 257, 4 and 5. The second question would be whether or not such a regulatory framework existed as at the date the IBC received the BBI bill. And finally, the question of whether or not the procedures that the IBC used were indeed lawful, to the extent that they could help and guide IBC in the verification and the certification process. Now to the first question, whether or not the IBC required a legal and regulatory framework. It is a summation that the IBC required a framework to guide it undertake its mandate under Article 254. The High Court agreed with that summation and found that at the time that the IBC received the BBI amendment bill, it required to have a form of a legal and regulatory framework to guide its work. You will find that finding at paragraph 752 of the High Court judgment. We therefore urge the court to affirm that finding for the following reasons. Number 1, Article 82(1) of the Constitution mandates Parliament to enact a legislation to provide for the conduct of referenda as well as elections in this country. It is therefore the obligation of Parliament to ensure that there is a law in existence that would seek to guide the processes that are associated with the referenda in this country. My lord, my ladies, there are many authorities from this court and as well as from the Supreme Court that hold that an election is not a one-day event, it's a process. Applying the same reasoning in this matter, we would urge this court to find as much that a referenda is not a one-day event, it's equally a process that starts right at the time a promoter comes up with the idea to amend the constitution, to the point of collecting signatures, to the point of taking them to IBC, to the point the IBC verifies them, certifies them, takes them to the county assemblies, takes them to parliament, and eventually to the referendum and the counting and the declaration of the referendum result. It cannot therefore be that the law that IBC seeks to rely on, that only provides on the conduct of the referendum, is the sufficient law. There is no law at all that provides for the verification and certification processes under Article 257(4) of the Constitution. Such a law has not been provided in this court because it does not exist, and it is not there. The law that this court was referred to exists in section 49 to 55 of the Elections Act. My lord, my ladies, a careful reading of that law will show that it does not in any of its provisions provide for the procedures on the correction and verification of signatures, on the procedures for certification, and on the procedures that are supposed to be undertaken by IBC insofar as its mandate and Article 257(4) and 5 are concerned. My lord, conscious of all the processes that are required to give effect to the referendum, the Constitution has therefore mandated Parliament to enact the law to regulate those processes. And the reason for this is not difficult to find. It is because each of the processes that are required in the context of the referendum, and in particular Article 257(4), right from the point of collecting signatures to the declaration of the referendum results, if at all, are important, they are fundamental in a democratic society. It cannot therefore be true that Article 257(4) and 5 is self-executing, as this court was told by the IBC. How does it execute itself? Well, it does not have any procedures or any provisions on how signatures are supposed to be collected, verified, and certified. My lord, having said so, the next thing we need to consider is the mandate that the promoters of a popular initiative have under Article 257(4). The obligation is to deliver the draft bill and the supporting signatures to the IBC in order for the IBC to be able to verify indeed that the draft bill and the proposals therein are supported by 1 million registered voters. The question therefore is, what is the role of the IBC upon receiving the draft bill and the supporting signatures? The High Court, at paragraph 734 of its judgment to 741, set out in detail what the IBC is required to do in order to give effect to the provisions of Article 257(4) and 5. The first thing the court said, which we seek to have this court affirm, is that the IBC must verify that the bill to amend the Constitution through a popular initiative is indeed supported by at least 1 million registered voters. my Lord, my ladies, it is also mentioned that IBC indeed understood its mandate to that extent very well. To that extent, I therefore refer the court to the record at page 3202 to page 3208.
Yes, continue.
Page 3202 to 3208. The record clearly indicates and provides evidence from the IBC itself. IBC in those pages, especially starting at page 320, came up with what it is calling the budget for signature verification. At page 3203, when it came up with a budget, it funded it to the National Treasury. At page 3203 of the record, we will find a document in form of a letter dated the 16th of December 2020 from the Cabinet Secretary, National Treasury and Planning. Paragraph 2 of that document clearly authorizes IBC to go ahead and spend some 93 million thereabout in the process and in order to undertake verification of signatures following the draft bill and the receipt of those signatures by the promoters of the draft bill, being the Building Bridges Initiative. All the way to paragraph 30, page 3205, the IBC itself acknowledges that it has a role to verify that indeed the signatures that have been presented to it are the ones that support the initiative. At page 3206 of the record, you will find a document from the IBC that seeks to make announcement for vacant positions for persons who are going to undertake the verification of signatures work at the IBC. It called members of the public to apply for that job, and it listed the criteria that it was seeking from those people. At page 3207, you will find a tweet from the Twitter handle from the IBC that informs members of the public that indeed IBC has started its verification processes of the signatures that it received in support of the BBI bill. Finally, at page 3308, you will find a document that is known as the Administrative Procedures for the verification of signatures in support of a constitutional amendment referendum. All along, and all those documents demonstrate one thing, that what the IBC sought to do was to verify the signatures that were submitted to it in support of the draft amendment bill. To that extent, therefore, we submit that for IBC to have been able to do that particular mandate constitutionally, it required some form of a regulatory framework to enable it to undertake that important constitutional obligation. My Lord, my ladies, Mr. Ngumbo informed and submitted in this court that Article 257(4) has three aspects. He referred to the aspect of the first one being an initiative, the second being verification, and the third being supported by 1 million registered voters. My Lord, my lady, we submit that he conveniently and properly sought to misguide the court by omitting the fourth aspect, which is a draft bill that is supported. The draft bill indicates that a promoter of a popular initiative cannot deliver the draft bill to IBC without the supporting signatures. So what is then the purpose of these supporting signatures? Or rather put differently, why did the Constitution deem it important that for a promoter who intends to amend the Constitution must collect supporting signatures and have them delivered to IBC and not DCI? What then was the intention behind that provision in the Constitution? Mr. Ngumbo made this court believe that the supporting signatures are not useful at all. In our view, it could not have been the intention of the drafters of the Constitution to have the signature requirement for cosmetic purposes. No. Had the Constitution envisaged that the IBC should use those other unique identifiers, as Mr. Ngumbo told this court, then nothing, my lords and my ladies, would have been easier than the Constitution to say so. To that extent, therefore, I seek to rely on paragraph 12J of the affidavit of Mr. Michael Goa, Michael Goa at paragraph 12J of his affidavit in opposing the petition before the High Court and in support of the IBC case, stated that a signature is just one of the unique identifiers that IBC can use to verify whether or not a supporter of the initiative is a registered voter. He states that IBC has other identifiers which are unique to IBC, such as a surname, for example, an ID number, the sex of the registered voter, the date of birth, and so on. Then the question is, why didn't the Constitution use any of these unique identifiers in order to identify, indeed, that the registered voter is the one who is supporting the initiative? I submit that there was a reason why the Constitution uses signatures, and that reason cannot be overlooked by this court or by the IBC. Mr. Ngumbo further informed this court that by requiring IBC to verify signatures, we are basically requesting the IBC to undertake forensic analysis and work that is a preserve of the DCI. My lord, my ladies, that summation is incorrect. We say so because Michael Ngoa's affidavit as well, at page 3287, that is paragraph 12K, paragraph 12K, it states that in respect of every registered voter, IBC has a record of all Form A's which contain the signature or thumbprint of a voter, the constituency of that voter, the county that voter comes from, the ward that voters come from, and so on. Therefore, it cannot be that IBC, where it says that it keeps Form A, which has all these details about a voter, including the signature of the thumbprint, can now purport to say that it does not have a means to verify the signatures, whereas it does hold those signatures. The question then is, do we need DCI to undertake a forensic analysis? We submit no. An analogy would be made. Every bank, if you have an account in any bank in this country, the bank has your signature. How does the bank verify that signature without having to undertake a forensic analysis from the DCI, as Mr. Ngumbo makes us want to believe. In addition to that, at page 3217, of the record, you will find a form produced by IBC in opposing Muhuri's petition. The form is titled Form for Collection of Supporters' Details and Signatures. The IBC envisaged and actually did create a format through which a promoter of a popular initiative would use to go out there and collect signatures. What are these signatures for that it intended, and what are they to do with them if they did not have an obligation to verify them upon receiving the signatures? Further, my lord, I refer you to paragraph 12(o) of the affidavit of Michael Goa, where it states that the responsibility of the IBC after verifying, it states so. It's not our evidence, it is IBC's evidence. The responsibility of the IBC after verifying signatures is to send the verified signatures to the promoters and public for confirmation that indeed they gave their signatures in support. So the question at this point is, did IBC do so? Did IBC at any point verify the signatures? Did it send them back to the public for verification? To answer that question, I refer the court to page 3340. Page 3340 of the record, where you will find a document called Notice of Interim Verified List of BBI Supporters. At paragraph 2 of that notice, the IBC states it undertook data cleaning exercise by removing incomplete records. That is, I'm quoting verbatim, that is, missing signatures, ID numbers and names, duplicates, and those not in the registered voters. What IBC then tells us, the members of the public, it did was to do a cleaning exercise. It undertook a data cleaning exercise as opposed to verifying the signatures. It never came out to provide a list that had proper supporters and their signatures that it had verified. What it did, it used again the unique identifiers in the list that it sought to upload in its website.
Council, you have 5 minutes to go.
Further on that issue, we submit that until now, the position of the IBC on this process is not known. I say so because Mr. Ngumbo told this court that IBC could not verify the signatures, but on further cross-examination or rather questioning by the member of the bench, Justice Honorable Kiage, he stated that IBC verified. The question therefore is, what did IBC do? It is not known. It is unknown, and that's why its actions are not accountable to anyone or any person. Mr. Ngumbo further informed this court that IBC did not have a database of signatures. Indeed, that evidence is also on record, and I refer you to page 3197 of the record, where you will find a letter by the IBC to Muhuri confirming that indeed it did not have a database of signatures. But all this contradicts IBC position, and it does so because it states, first of all, it has a Form A in its custody. The Form A apparently has the signatures of every registered voter. It further goes and informs my client that it does not have a database. So the position until now of the IBC cannot be ascertained, not by this court, not by any other independent person, because whatever it did to do was not accountable and was not in any way verifiable. On that issue again, Mr. Ngumbo gave an analogy to this court. He told this court a few days ago, Kenyans were able to complain to the registrar of political parties that they had been registered without their consent as members of various political parties in this country. Why were Kenyans able to make that public outcry? They were able to do so because the registrar of political parties maintains a system that is verifiable, simple, transparent, and credible. All that a Kenyan citizen needed to do was to go to e-citizen platform, input their ID number, and have the details of whether or not they're registered as a member of a political party. Can the same process be said of the IBC, and in the manner in which it is sought to conduct its mandate under Article 257(4)? We answer no. IBC did not have a simple, accessible, and verifiable process that it could have used in relation to satisfy that indeed the initiative was supported by more than 1 million registered voters. Finally, before I log off, I would like to refer this court to the administrative procedures that apparently the IBC said it used. The IBC, in its own administrative procedures, and those procedures you'll find them at page 3208 to 3216 of the record, it states step by step what it is sought to do and how it's sought to do it. From paragraph J, it states step by step on verification of signatures, getting budgetary allocation, going to verify both the print and the soft copy of the signatures. It states clearly what it was supposed to do, but it did follow its own procedures. It did not. What it did was to do a data cleaning exercise. We therefore urge this court to affirm the High Court findings that the IBC, in the manner in which it carried out its mandate under Article 257(4), violated the Constitution as well as its own procedures that it had developed to assist the court.
Thank you very much, Counsel.
Thank you, my lord, and I will seek, because I could not cover everything that I intended to refer the court to submissions.
Yes,
and I
thank you
believe
very
that
much.
they'll do so. Thank you very much.
Thank you. Senior Hanzo Amino.
Permit me to say good morning, my Lord.
Good morning to the Femino.
Yeah. My Lord, may I say I'm very proud and very happy to have the privilege of appearing before your Lordships. My Lord, before I go on, Justice Musinga, President of the Court of Appeal, we thank you very much for the efforts you have taken to put us in very civilized surroundings. I know what it means to have had to put up such a structure at a very short notice. We remain most grateful to you.
Thank you.
My Lord, may I take this opportunity to congratulate my Lady Justice Okwegu. Lady Justice Okwegu, may I say to you, we remain proud of you. I have had the privilege of appearing before you since the days you are magistrate, a High Court judge, and Court of Appeal. Some of us who have known you for a long time will remain most proud of you, and I convey to you my sincere congratulations and wish you very well. My Lord Justice Tuyot, I equally congratulate you for having been elevated to the Court of Appeal. It was always a pleasure to appear before you when you are High Court judge. I always looked forward to the time I'm going to appear before you, and I was happy with the points you used to raise, questions you used to ask me, to interrogate me, and I look forward to continuing to appear before you. I wish you very well on the bench. My Lords, may I say one or two things? The President of the Republic of Kenya, the Honorable Mr. Justice, the Honorable Uhuru Kenyatta, has filed an application, and I'm inviting you very respectfully, my Lords, that you do not take note of the application that he has made before you at all. My Lord, while he was at Kisumu, he made certain remarks about judges. My Lord, he has failed to get two judges who are involved in this case in the High Court to be sworn in as Court of Appeal judges. That is Justice Udunga and his colleague who have not been sworn in at all. My Lord, when you come to the court, you must come with clean hands. The President has not come to this court with clean hands at all. And I'm humbly urging you that you borrow a leaf from South Africa. You borrow a leaf from India and Pakistan and say to him, no, we shall not hear you. The orders that were made by the Court of Appeal must stand. He has deliberately refused to swear in judges. My Lord, it's my humble submission that when you are coming before a court, you cannot despise a judge and at the same time you appear before a judge and you expect that judge to give you orders at all. May I say, my Lords, when you appear before your Lordships, we come with tremendous humility. We speak politely to you. We praise you. That praising, that humility, and that courtesy that we extend to the court is not for you personally. It's for the good of the entire country of Kenya, to get our people to continue to have confidence in the judiciary and in the administration of judges, of justice in our country. And when you have a president who is not obeying court orders, when you have a president who is demeaning judges before the public, This court must stand firm and say to him, no, we shall not hear you. We shall not give you orders at all. Again, I respectfully urge you, you borrow a leaf from India. You borrow a leaf from Pakistan. You borrow a leaf from South Africa. Decline respectfully and say to him, we shall not hear you, and whatever complaints you have, raise those complaints before another court, but not this court at all. My lords, the 2010 Constitution, perhaps before I go on with that, I have made a list, my lords, which I may give you those. I have made a list of some authorities or some books I have, which I know that your lordship may not be having them. And I would be prepared to list them to the court through the registrar if that would. My lords, I have included them in a list of authorities here. If you may permit me to hand them to you.
But be mindful about your time, eh?
6. No, I know, my lord, as usual, you'll be kind to me.
No, not today, Dr. Haminwa, Senior Counsel. You have precisely 23 minutes now remaining.
Yes. My lords, the books I have are in constitutional amendments by Yaniv Roznai, Constitutional and Political Theory by Ernest Wolfgang, a constitutional judge of Germany, Making Constitutions in Deeply Divided Society by Hannah Lerner, Constitutional Amendments by Richard Albert, and an amendable Constitution by Richard Albert Batel Embra, The Foundations and Constitutions of Constitutional Amendment. There is one book I have not brought to the court, but I'll make it available if the registrar asks me. It's called The Theory of Imperfections in Constitutional Making and Constitutional Amendments.
Yes.
My lords, the Constitution of Kenya 2010 was a response to two things: to the rotten history of this country,
yes,
and to development of international jurisprudence or global jurisprudence. My lords, those of you who are young may not know that this country has a rotten history. This is set out in two books. One is Kenya, A History Since Independence by Professor Charles Hornsby, Professor of International History, I think, at the University in Australia. The other one is Kenya Between Hope and Despair by Daniel Brandt. My lords, Condoleezza Rice, who is now, I believe, a professor at Stanford University, when she was security advisor to President George Bush, in her new book that has come out, Democracy, Condoleezza Rice, at page 127, there is only one sentence, my lords, which I would like to read to you. At page 217. On Inauguration Day, that's our President Mike Kibaki, told Kenyans that he was inheriting a country badly ravaged by years of misrule and ineptitude. That was a correct statement. There were assassinations in the country. Pinto, J.M. Kariuki, Tom Mboya, William Ouko, and etc. Many assassinations. People died in suspicious circumstances. Some left the country in exile. People like Ngugi wa Thiong'o, Mazurui, they left the country. There was rampant corruption in the country. My lords, the Constitution, the 20th Constitution, was intended to take care of this. The judiciary was not spared. There was no security for judges at all. Some judges, some judicial officers died under suspicious circumstances. These were things that the new Constitution was supposed to take care of. And my lords, if you read the Constitution very carefully, the way I do, you will find that it does take care of certain things. Certain officers are entrenched. The office of the DPP, the office of the Inspector General, the judiciary, devolution, the preamble, the sovereignty of the people, the leadership code, and etc. My lords, all these things were included in the 2010 Constitution to send a message to Kenyans and the whole world: never again shall we go through this kind of life. Never again shall we go through this. The way the Japanese Constitution has a provisions to the effect that never again shall we have war. The way the Cuban Constitution has a provision, never again shall we go to capitalism. We say to the whole world that never again shall Kenya have this kind of life. And my lord, this is repeated in the Constitution. If I may refer you to Article 255 of our Constitution, dealing with amendments. 255. My lords, if you read 255, 256, and I believe, yes, 255, 256, and 257, it emerges very clearly